will not automatically get ownership of your spouse's house if they own it only in their name. So it really depends on if they have a will or they do not have a will. Either way, the property will have to go through the probate process if it's owned in their name alone before it can be distributed out to you as the surviving spouse. And so what's going to happen is if you have a will and it gives direction in there that the house will go to the surviving spouse, it will still have to go through the probate process because a will does not avoid probate. And then after that 1 to 2 year probate process happens, then the surviving spouse will have ownership of that property if it doesn't have to get sold to pay off creditors during the probate process. The other way is if you do not have a will, it will have to get distributed per the intestate laws of your state. As an example, in Georgia, their kids and their surviving spouse will each have to split the assets evenly between them, with the surviving spouse getting a minimum of 1/3. So if you have 2 kids and a surviving spouse, they each get 1/3 of that property, and they are all co-owners at that point, which can create issues. And so either way, the property will have to go through the probate process. How it gets distributed depends on whether you have a will or you do not. And if you want to avoid the probate process, you have a couple options. You could do joint tenants rights to survivorship, you could do transfer on death deed, or you could do a revocable trust. There's pros and cons with each one. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.